Many of you are aware that the states and the union territories that are visible on the map of India today were not always the same. They were created and redrawn gradually over time. But have you ever examined the constitutional machinery that made this transformation possible? Hello everyone, in this video we are looking at those constitutional provisions which have enabled the continuous change of Indian political map. As you know, India's territorial structure is dynamic. It has changed multiple times through the creation of new states, alteration of boundaries and even change of names. And constitutional foundation for all this lies in Article 2, 3 and 4 of the Indian Constitution. Now, let's closely examine each of these articles which empowers the Parliament to reshape the map of India. Firstly, referring to Article 2 of Indian Constitution, it empowers Parliament to admit into the Union or establish new states on such terms and conditions as it thinks fit. This provision primarily applies to those territories that were not originally part of India. A classic example is Sikkim, which in 1975 transitioned from being an associate state under 35th Constitutional Amendment to becoming a full-fledged state through 36th Constitutional Amendment. Similarly, Goa liberated from Portuguese rule in 1961 and was later granted full statehood in 1987. Thus, Article 2 deals essentially with admission or establishment of territories in the Indian Union. Secondly, referring to more powerful and frequently invoked provision, that is Article 3 of the Indian Constitution. It enables Parliament to exercise four main powers under this provision, that is, to form a new state by separating territory from an existing state, to increase or diminish the area of any state, to alter the boundaries of any state, and even to change the name of any state. In simple terms, Parliament can internally redraw India's political map. This is, however, a procedural safeguard. If a bill under Article 3 affects area, boundary or name of a state, the President must refer the bill to the concerned state legislature. But this is where the constitutional nuance lies. The opinion of the state legislature is not binding on the Parliament. This clearly demonstrates the unitary tilt embedded in India's federal structure. To truly appreciate this power, we must understand the historical evolution of creation of states in India. At the time of independence in the year 1947, India was not neatly divided into the present-day states. There were British provinces and more than 500 princely states. Through political integration led by leaders such as Sardar Vallabhbhai Patel, these territories were consolidated and reorganized into Part A, B, C and D states. However, linguistic identity soon emerged as a powerful force demanding reorganization. In 1953, following the death of Patti Sri Ramalu after a prolonged hunger strike demanding a Telugu-speaking state, Andhra Pradesh was created. This marked a turning point and led to the appointment of State Reorganization Commission. Acting upon its recommendations, Parliament enacted State Reorganization Act 1956, which reorganized state boundaries primarily on linguistic lines. This remains the most extensive territorial restructuring in Indian history. Subsequently, India continued to evolve territorially. In 1960, Maharashtra and Gujarat were carved out of erstwhile Bombay states. Haryana emerged from Punjab in 1966. In the year 2000, three new states were formed, that is Chhattisgarh, Uttarakhand and Jharkhand. These were created to address administrative efficiency and regional aspiration. In 2014, Telangana was carved out of Andhra Pradesh after a prolonged political movement. Each of these transformations was carried out under Article 3. A more recent and significant example occurred in 2019 when the Parliament enacted Jammu and Kashmir Reorganization Act. Through this legislation, the former state of Jammu and Kashmir was bifurcated into two union territories, that is Jammu and Kashmir and Ladakh. This demonstrated the full constitutional amplitude of Parliament's authority under Article 3. And finally, referring to Article 4 of the Indian Constitution, it states that any laws made under Article 2 and 3 shall include supplemental, incidental and consequential provisions. Most importantly, it clarifies that such laws shall not be deemed to be a constitutional amendments under Article 368. This means that even though first schedule and the fourth schedule may be amended, it doesn't require special majority. And thus, I would like to conclude stating that The living map of India, from Sikkim's admission to Telangana's creation and the reorganization of Jammu Kashmir, India's map has evolved constantly. Articles 2, 3, and 4 together form the constitutional machinery that allow India to adapt to linguistic demands, cultural identity, administrative efficiency, and political realities. Thus, Indian constitution is not rigid when it comes to territorial governance. It is pragmatic, flexible, and responsive. The map you see today is not permanent. It is constitutional possibility subjected to parliamentary will.